Welcome to the Supreme Court Podcast.
All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
What happens when a public official bypasses the public bidding requirement in a government transaction? Can negotiated procurement justify disregarding public bidding, which is the default mode of procurement under RA 9184? In 2009, former actor and Pagsanghan Laguna Mayor Jeorge Ejercito Estregan and other local officials were charged with violating Republic Act No. 3019, or the Anti-Graft and Corrupt Practices Act, and Republic Act No. 9184, or the Government Procurement Reform Act, for allegedly entering into a Memorandum of Agreement with First Rapid Scare Ventures, or FRVC, without public bidding. Under this agreement, FRCV was to provide accident insurance for tourists and boatmen at the Pagsanghan Gorge Tourist Zone, even though the company did not have a license from the Insurance Commission. The Office of the Ombudsman filed charges against Estregan, Pagsanghan Vice Mayor Crisostomo Villar, and 6 councilors before the Sandiganbayan. Vice Mayor Villar was acquitted for lack of evidence, while Estregan, the councilors, and FRCV proprietor Marilyn Bruel were convicted. The Sandiganbayan found that Estregan acted with evident bad faith by using his office to bind the municipality of Pagsanghan in a contract with FRCV without the requisite Bids and Awards Committee evaluation, violating the Government Procurement Reform Act and the Local Government Code. Estregan and the others appealed to the Supreme Court, with Estregan claiming that public bidding was not required for the municipality's accident insurance program and that the Memorandum of Agreement with FRCV did not constitute an insurance contract. The Supreme Court upheld the convictions of Estregan and Bruel for violation of Section 3E of the Anti-Graft and Corrupt Practices Act and sentenced them to up to 8 years in prison, with perpetual disqualification from public office. The municipal councilors were acquitted on grounds of reasonable doubt. Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 18th of July 2025. Today we talk about the requirement of competitive public bidding in government procurements and its difference from negotiated procurement within the context of People of the Philippines versus Jeorge Ejercito Estregan, GR number 248699, penned by Supreme Court Associate Justice Ricardo Rosario and decided on February 5, 2025. And joining us to talk about this case is Sandiganbayan Associate Justice Theresa Dolores C. Gomez-Estoesta, Professorial Lecturer of the Philippine Judicial Academy. Justice Tay, thank you again for coming on board on the Supreme Court Podcast.
Thank you too, Attorney Mike. This is my second time and I've enjoyed it a lot.
All right. Perhaps we can begin our discussion, Justice Tay, with a brief explanation of what is public bidding and how is it important in government transactions?
Yes. When we say public bidding, competitive process ito. So this is the time where the government will invite interested and qualified suppliers, contractors, or consultants to submit sealed bids for the procurement of goods, infrastructure projects, or consulting services. Ito yung default mode under Republic Act 9184. I have to mention, Attorney Mike, at this instance, para clear sa mga tagapakinig natin, that 9184 is no longer the law when it comes to procurement contracts. Na-supersede na ito ng Republic Act 12009, where competitive public bidding is now any of the modes of procurement. So hindi na siya default.
And but for the purpose of this case, it's RA 9184 and it's the default mode.
Yes,
right.
That's right.
Let me just also ask you, Justice Tay, who can participate in public bidding and what types of projects or purchases require public bidding?
Yes. So kung 9184 pa rin, any interested and eligible supplier, contractor, or consultant, whether local or foreign, can participate in public bidding as long as they meet the eligibility requirements. Importante ito, Attorney Mike, yung eligibility requirements. When we talk of eligibility requirements, it will typically include an assessment of legal, technical, and financial capability. So when we talk of legal documents, ito yung mga may license ba siya, may business registration, may tax clearance. Technical documents, we talk of mga relevant experience, expertise, equipment, and personnel. Then financial documents, we talk of the prospective bidder's financial capacity to undertake the contract. So the types of projects that should require public bidding are procurement of goods, such as sa mga opisina natin, office supplies, equipment, service vehicles, computers, ICT equipment, firearms, handheld radios for our security personnel, infrastructure projects, which may refer to buildings or the rehabilitation or renovation thereof, and then consulting services, which will refer to engineering and architectural designs, feasibility studies, or legal, auditing, and financial consulting.
In this case, there was a memorandum of agreement between the municipality of Pagsanghan, Laguna, and First Rapids Care Ventures for First Rapids to provide accident protection and assistance, or APA. What was wrong with this agreement, and why did it lead to graft charges against Jeorge Ejercito?
Yes. The MOA was supposed to generate a good intent to indemnify against freak accidents and provide protection and financial assistance for all tourists. Di ba mahilig ang mga tourists sa shooting the rapids sa Pagsanghan Falls. At saka mga boatmen, mga bangkeros who had to ply the route.
Right.
However, the manner to which the contract was made was irregular. Unang-una, the agreement did not undergo the procurement process under RA 9184, meaning the Bids and Awards Committee did not conduct it. Instead, it was arrogated upon the municipal mayor himself when he used his own office to obligate the municipality to enter into a contract with First Rapids without the requisite determination by the back of its qualification. Pangalawa,
And the
yes,
mayor here is Jeorge Ejercito.
George Ejercito, that's right. Famous Mayor
Or
George
E.R.
Ejercito.
Ejercito.
Yes. The second, the contract had no budget linkage. It had no approved budget for the contract, or what we call the ABC, which is why the BAC refused to undergo procurement for it. Kasi basic sa PD 1445 or the Government Auditing Code of the Philippines that if there is no budget appropriation, there cannot be any procurement. Diba, we talk about our annual procurement plans where
Right.
there's an appropriation. At this instance, there was none. So the mayor could not even proceed with the procurement process. The third is, and this is the more important one because it really delved into the violation of Section 3E of Republic Act 3019, the service provider or First Rapids did not meet the eligibility requirements under the law, requiring legal, financial, and technical capacity to perform a government contract, and yet the municipal mayor presented First Rapids before the Sangguniang Bayan as having the capacity to contract as if it was already pre-qualified as to its eligibility requirements.
And there was an issue here
Yes.
about First Rapids offering an insurance contract. How significant was this characterization of the MOA or the Memorandum of Agreement? Because it was the Insurance Commission itself which says
Yes.
this is an insurance contract.
Yes.
So how significant was that discussion?
Very significant because it will determine whether or not procurement will ensue. Because when the witness from the Insurance Commission stated that the MOA was a contract of insurance, it only meant that the MOA was within the coverage of the definition of goods under RA 9184, which means it should undergo procurement process. For the accused kasi they wanted to get out of it by saying the MOA was only a special contract, it did not involve the municipality's public funds because it is taken from the boat service fee that's paid for by the tourists themselves, and so it is not an insurance contract necessitating procurement. But these claims were all debunked by the Supreme Court, stating that the MOA was indeed a contract of insurance. Kasi you look at the object, the consideration of the MOA, and it would say that it undertakes to indemnify against loss, damage, or liability arising from an unknown or contingent event. So it was therefore a contract for the procurement of goods that needs procurement.
Did it matter that because FRCV was trying to wiggle its way out by insisting it was not engaged in the insurance business, because it was saying it was just engaged in providing training to boatmen?
Yes.
Did that argument work for them?
No, it did not also because other than a procurement for goods, which is an insurance contract, even if the accused would say that it was service-oriented contract, it can likewise be qualified as a consulting services under Republic Act 9184, which means that for the technical training provided, it will still also need procurement process.
So whether it's a procurement for goods or procurement for consulting services, both will have to undergo competitive bidding, at least
Yes.
under RA 9184.
Yes.
Instead of going through public bidding, the default mode of procurement under RA 9184, the Municipal Council passed Municipal Ordinance number 15-20 or Municipal Ordinance number 15-2008, which authorized resort to the alternative method of procurement known as negotiated procurement. How is negotiated procurement different from public bidding? And was the Municipal Council justified in resorting to it?
Negotiated procurement is a method of procurement where the procuring entity directly negotiates a contract with a technically, legally, and financially capable supplier, contractor, or consultant. However, under the IRR of Republic Act 9184, this may only be resorted to under extraordinary circumstances. So the procurement should have been undertaken by BAC, and it should have recommended that default mode of competitive public bidding cannot be made. So it recommends an alternative mode, in this circumstance, negotiated procurement. But there are circumstances. One, either of these circumstances, two failed biddings. Wala pa ngang bidding.
Yes.
So this did not qualify. Next, emergency cases. In case of imminent danger to life or property, pag may tourist naman shooting the rapids, there is no imminent danger there. There could be freak accidents, but definitely it was not in the context of an emergency.
Right. Right. Now, in criminal cases involving a violation of Section 3E of RA 3019, is it enough to show that there was a violation of the procurement laws? Or are there other elements that you need to prove before you can say that you're guilty of this crime?
Yes, that's a very relevant question, Attorney Mike, because for those who may not know this, there is a landmark case decided by Justice Kagiwa in Martel versus People, GR number 2247-20223, February 2, 2021, which stated that a violation of procurement law by itself does not automatically give rise to violation of RA 3019. Now, there may be violations of the applicable procurement laws, but the same does not mean that the elements of violation of 3E of 3019 are already committed. Because for there to be a violation, kailangan merong proof beyond reasonable doubt of the following elements. So, hindi lang violation ng procurement. The court has to assess through the following elements. First, the first element is that accuses a public official performing official, administrative, or judicial functions. The second one is the violation of the procurement law caused undue injury to any party or gave any private party unwarranted benefits, advantage, or preference. Napaka-technical ng mga to, Attorney Mike.
Right.
If you allow me to
Yes, please.
to state them, ito kasing case na to, it involved unwarranted benefit. So, sa Supreme Court decisions, this will refer to any advantage, preference, or favor given to a private party by a public officer in the discharge of his official functions. The term unwarranted benefit refers to any advantage, preference, or favor given to a private party by a public officer in the discharge of his official functions, which is not merited, deserved, or legitimately obtained according to established procedures or laws. It essentially means a benefit that is not rightfully due to the recipient. Parang pinaboran mo lang talaga. Ganun
Yes.
lang. And then the third element is the accused acted with evident bad faith, manifest partiality, or gross inexcusable negligence. Again, these terms are really technical. Manifest partiality, it would refer to a clear showing of bias or an unwarranted favor towards a particular party. It's like, regardless of the qualifications or the eligibility requirements, you just give due consideration or favor to that party. And evident bad faith, this will involve a dishonest intention or a deliberate intent to cause harm.
So if some of those elements or one of those elements, Justice Tay, is not met, can the public official still be liable for administrative charges?
Yes. Administrative charges, yes, other than criminal. That is correct.
All right. Now, in the end here, the SC, the Supreme Court, acquitted the municipal councilors, but it convicted the mayor, Estregan, and Bruel, who was the head of First Rapids. Why was this the case? Did they perform different functions in a way? Why was their liability different?
I guess this is where you understand what is proof beyond reasonable doubt is to arrive at a judgment of conviction. For the municipal councilors, the Supreme Court found that the prosecution failed to prove the elements of 3E 3019 beyond reasonable doubt. Because when the municipal ordinance was passed, you were referring to 15/2008, it merely authorized the municipal mayor to transact, negotiate, and enter a contract between the municipality and, quote-unquote, any competent and qualified entity which can provide the APA services or the accident protection and assistance. Meaning to say, it did not specify who the contracting party was. It still
Right.
depends on their determination and qualification, pre-qualification. But even assuming that resorting to negotiated procurement, because that was what the Sandiganbayan actually sanctioned or ratified to do for the municipal mayor, the municipal councilors did not show manifest partiality or unwarranted benefit towards the supplier, because the ordinance itself stated any competent and qualified entity. So such entity was yet to be determined. So there was no unwarranted benefit given. So meaning to say, the Supreme Court said it did not even prevent the municipal mayor from resorting to public bidding, because it only authorized it to enter into a contract for that indemnity agreement. So that was
Right.
the reason why. So hence the acquittal. But for the municipal mayor and the service provider, that's a different context. So under the umbrella of conspiracy, the municipal mayor showed manifest partiality and evident bad faith when he entered a MOA with First Rapids despite its lack of legal, financial, and technical eligibility. If I would recall from the case, wala nga certificate of authority ang First Rapids from the Insurance Commission.
Right.
So how can it provide insurance indemnity contract? So how can it do that? Not only that, yung kanyang registration sa Department of Trade and Industry and the Bureau of Internal Revenue, it was made a few days before it submitted a written proposal for the indemnity agreement. So obviously, it was a new company, and if you check the records of the BIR and the DTI, its business is really in relation to specialized services or other computer-related activities. Hindi siya talaga pang APA services. So
Right.
how can you then even consider the insurance company for supplying the needs for the indemnity
Right.
contract?
And it's important to point out, Justice Day, that it's not just the government official who's
Yes.
going to be held liable. If you are the service provider who enters into a contract
Yes.
with a government official, with a government entity, and you're not qualified, you will also be liable under the same law.
Yes, that's right.
And just a reminder, Justice Day, you mentioned earlier that there's now a new procurement law.
Yes.
Would this have changed the way this case was decided, or what's the significance of the new law?
The new law, the significance as far as this case is concerned is that competitive bidding is no longer the default mode.
Right.
But resorting to negotiated procurement, it will have the same circumstances. It will have the same exceptional circumstances before it is resorted to.
Meaning it's an emergency, or two failed biddings.
and all the other circumstances. Lacking that, still negotiated procurement cannot be resorted to.
So in short, you're saying that the outcome of this case would have been the same even if the new law were implemented.
Yes, that's
All right.
correct.
All right. So very, very interesting. And just to sum up our discussion, Justice Day, what happens when a public official bypasses the public bidding requirement in a government transaction? And can the use of negotiated procurement justify disregarding the legal process and establish procurement rules?
Unfortunately, it cannot, despite the intent of the public official. Bypassing the public bidding requirement in a government transaction under RA 9184, to which this case is within that context, without valid justification is a serious violation of Philippine procurement law, and it can result in criminal, civil, and administrative liability, as you were asking. So tatlo agad criminal, civil, administrative. To recall nga, di ba, negotiated procurement, kailangan exceptional lang, legally defined circumstances. If you don't meet that, with a clear provision of the 9184, everything all else is violated. I've met a lot of public officials who have been dismissed from their own jobs because of violations of procurement law. So it's really that unfortunate.
All right. So Justice Day, last question for me. What's our key takeaway from this case?
Yes, public bidding is the rule, within the context of 9184, negotiated procurement is the rare exception and not a loophole. So if the public official disregards the bidding requirement without strictly following the conditions and procedures for alternative procurement, the act becomes illegal and may lead to serious sanctions that are criminal, civil, and administrative in nature. For the Sandiganbayan, sorry if I have to put that in, no, Attorney Mike, I can say that 90% of the criminal cases filed in our court will involve issues on procurement. So that's one of the consequences I am referring to. That's why you really have anybody, a public official involved in the procurement process, should really know the technicalities involved in the procurement law.
That's a very interesting statistic,
Yes.
Justice Day, and it's good to have you here at
Yes.
least because you can speak authoritatively about the most common cases before the
Yes.
Sandiganbayan. So thank you once again for joining us in our
Thank you
podcast.
for inviting me as a guest, Attorney Mike.
All right.
Thank you.
And to our listeners, if you wish to read the full text of the decision of the Supreme Court, please visit the Supreme Court website at sc.judiciary.gov.ph and search for GR number 248699, People of the Philippines versus Jeorge Ejercito Estregan. Here's Steve Atendido Beltran, Supreme Court Information Officer, for recent updates about the court.
From the Supreme Court of the Philippines, here's the latest. The Supreme Court has ruled that the Commission on Elections, or COMELEC, can hold special elections to fill vacant congressional seats even without a resolution from Congress. In a decision written by Associate Justice Ramon Paul Hernando, the SC en banc dismissed the petition filed by Elroy John Hagedorn to compel the House of Representatives to officially declare a vacancy in the 3rd Legislative District of Palawan and call for a special election. The seat became vacant after Representative Edward Hagedorn, who was elected in 2022, passed away on October 3, 2023. Although the May 2025 elections made Elroy's petition moot, the SC still reviewed the case and ruled that Congress cannot be forced to pass a resolution certifying the vacancy and calling a special election, as this requirement was removed by a later law, Republic Act No. 7166. If a seat becomes vacant at least 1 year before the end of the term, COMELEC must conduct a special election within 60 to 90 days from such vacancy. In another decision, the SC has reiterated that hiding one's homosexuality from a spouse can be considered fraud and may be used as a ground to annul a marriage. The SC Second Division, through Associate Justice Antonio Co. Jr., annulled the marriage of a woman whose husband concealed his homosexuality before they got married. The SC ruled that the woman's consent to the marriage was obtained through fraud, and that the marriage must be annulled on the ground of fraudulent concealment of sexuality, following Article 45, Paragraph 3, in relation to Article 46, Paragraph 4 of the Family Code. It found that the husband intentionally hid his homosexuality to persuade the woman to stay and marry him. In another case, the SC has dismissed a court sheriff who was found guilty of accepting money in connection with a drug case. In a per curiam decision, the SC en banc dismissed Dwight Aldwin Geronimo, Sheriff 4 of Branch 121 Regional Trial Court, Imus City, Cavite, revoking all his retirement benefits and permanently banning him from government employment. Under Section 1, Canon 1 of the Code of Conduct for Court Personnel should not use their position for personal gain. Section 2 of the same canon forbids them from accepting gifts that could influence their official actions. Meanwhile, on Tuesday, the Office of the 2025 Sharia Special Bar Examinations, or SSBE Chairperson, Associate Justice Antonio Co. Jr., announced that the list of successful 2025 SSBE examinees will be officially released on July 22, 2025, while the oath-taking and roll-signing ceremonies for the successful SSBE examinees will be held on August 6, 2025 at the Manila Hotel. Further details may be found at the 2025 SSBE notice dated July 15, 2025. The 2025 SSBE was held on May 25 and 28, 2025. On Thursday, the Supreme Court confirmed that on July 16, 2025, several branches of the Pasig Regional Trial Court, or RTC, received email messages containing death threats directed at unnamed judges. Pasig RTC followed standard security protocols to secure the safety of judges, court personnel, court users, and the public. the SC, through the Office of the Judiciary Marshals, swiftly launched an investigation in coordination with the Philippine National Police Anti-Cybercrime Group and the National Bureau of Investigation Anti-Cybercrime Division. Finally, on Tuesday, the SC has announced a design competition to create the official seal of trial courts in the Philippines. This competition aims to develop a unified and meaningful seal that will represent the identity of all first and second level courts and distinguish them from other courts in the judiciary. The contest is open to all. Entries must be sent by email to sealdesign@judiciary.gov.ph. Deadline is on August 15, 2025. You are now up to date with the Philippine Supreme Court. I am Tiffany Doubletran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Atty. Karen Martinez, Jay Rimpilio, and May Sibal as researchers, Brian Austria, Don Ryan Balza, Lauren Solanio, Austin Aliscad, and Bea Batong as audio and video editors, and Tyke Flores and Jerome Batumalaki as web editors.